So good morning again. Today I'm going to be talking about, well, the topic is cathedrals and other charities. It's mainly the other charities, but cathedrals are quite a nice little diversion to talk about some of the issues that are relevant to many charities of many different sorts. What I'm going to be talking about today is, first of all, I'm going to have a quick look at the third sector, which is a phrase that's probably familiar to most of you, but some of you it may not be quite so familiar with. So I'll just explain what we mean when we talk about the third sector. I'll be talking about what it is that makes charities different from other organisations and what issues there are that tend to lead people to decide to set up their organisation as a charity rather than as some other type of organisation. After that, I want to lift the lid and look at the anatomy of a charity itself. In particular, look at the assets that there will be inside a charity and the extent to which you are going to be able to use them. That's not always going to be the case for all charities. And then having cathedrals in the heading, that's the point at which I will then be looking in a little more detail at cathedrals, really as a real-life example of what you might find in a well-established and reasonably complex charity and the issues that could arise in advising either the trustees or actually dealing with the formal insolvency of an organisation of that sort. And I want to finish by looking at some of the typical issues in insolvencies, really my own experience of what tends to be important in dealing with cases like this. So let's look at the third sector. The economy is sometimes divided into three components: private enterprise, the state sector, and the third sector, which is really everything else. Now, it's often a bit more blurred than the first diagram showed as to exactly where the dividing line is between each of those, but charities are most definitely within the third sector. So let's have a look at the third sector in a little bit more detail now and see what we have there. Not only do we have charities, but we also tend to have other not-for-profits, voluntary groups, social enterprises and cooperatives are all examples of third sector organisations. So let's look at what makes a third sector organisation different. And there are three factors, I think. The first one is they're not in the state sector, so that means that they are not independent. Sorry, it means that they are independent of government. But having said that, they are often dependent upon grant funding from national or local government, or in the past from the EU as well. And they can often be a way for the government to deliver government policy. So, for example, we have housing associations, which are charities, which are supported by government money to some extent, and which are there to implement government policy as well. The second component of a third sector organisation is it's sometimes described as not-for-profit. It's more accurate to say it's not for personal profit. Organisations in the third sector need to operate at a surplus as a general policy. If they don't, if they continually operate as a deficit, then they do end up as the subject of our interest. They end up insolvent. But it is called a surplus rather than a profit, and the surplus gets reinvested in the organisation. It is not used to pay a return for the use of the capital in the organisation. And the third thing that distinguishes third sector organisations, and this is perhaps the hardest to pin down and define, is they tend to be value-driven organisations. So they exist for a particular purpose. They are trying to achieve a particular objective, and that is more important for them than anything else that they do. And not only is that important for the organisation, but it tends to be important for the people in the organisation. The trustees and the employees tend to get involved because the organisation is one with values that resonate with them. And again, I've got a list there of the examples of the sort of third sector organisations that we can come across: charities, voluntary groups, social enterprises, cooperatives. There are others. It's just charities we're going to be talking about this morning. So let's now move on to talk about what it is that makes charities different. What is it that puts an organisation into the box marked charity? And there are two things that are important here. Firstly, the organisation must be operating for charitable purposes. And the second thing is that the organisation must not be operating to produce a private benefit. So if you've got those two factors, charitable purposes and absence of private benefit, then you have a charity. And you always have a charity when you have those two components coming together. So let's look at the list of charitable purposes. These are from the Charity Act 2011. My apologies to the charity specialists watching this. This is a very, very crude summary of those charitable purposes. There's a lot more detail than this, of course. The big four, of course, are relief of poverty, education, religion, or promotion of health. And you've got others as well, some of which are relatively new, things like promotion of communities and citizenship. You've got art, culture, heritage and science charities. You've got the promotion of amateur sport, promotion of human rights and tolerance. You have environmental charities pursuing green objectives. You have charities that are there to benefit disadvantaged people, which is a little bit wider than the traditional relief from poverty purpose. Animal welfare is a purpose, and also supporting members of the uniformed services is a charitable purpose. That's not a comprehensive list. There are exceptions and additions and historical accidents. The crucial thing is that in addition to one of those charitable purposes, or more than one of those charitable purposes, there has to be public benefit as well. And if you have those two combinations, charitable purposes and public benefit, you have a charity. So, for example, wallpapering a flat could possibly squeeze into the heritage purpose if you were setting up a charity for that purpose. If it was a historic building and the wallpapering was to preserve the building for cultural heritage, you could perhaps get away with wallpapering a flat as being a charitable purpose, but there would have to be public benefit. So if it was the flat that you were living in as your private home, it ain't going to be a charity. Let's look at what factors are important when deciding to set up as a charity or not. One that I haven't got on the list there is just public recognition. Everybody knows more or less what a charity is, and being able to describe yourself as a charity does give you access to the media. It helps you to promote your objectives. It does help with fundraising because people feel that they know what it is that you do without you having to go into too much detail. The more tangible benefits are particularly around fundraising, and the most important one, I think, for most charities seems to be the access to grant funding. That if you are a charity, there are grants available from all sorts of organisations, from other charities, from the state, and it gives you the chance to tap into that as a source of funding. For some charities, the benefit of being able to recover gift aid on donations can be hugely important as well. There are also tax benefits associated with income and corporation tax, stamp duty, VAT, inheritance tax, which again can be very important for some charities that get a lot of funding from legacies. And actually, business rates relief is hugely important in terms of controlling the overhead costs of many charities as well. The disadvantages of being a charity, well, one is that your permitted activities are going to be limited to your charitable objectives, to public benefit, And if you want to diversify, you might find that the funds that you have got, so although you might be a very well-funded charity, you may have cash available that would appear to give you the chance to diversify. In actual fact, you may not be able to use the cash that you've got to diversify. Commercial organisations find it much, much easier to respond to opportunities quickly and efficiently. Raising capital can be difficult because, of course, you cannot offer a return to investors for equity capital. And when you do have funds provided, whether it's by way of grant or gift, then there can be restrictions on the use of those funds that limits how you can use them. And then there's also the issue of regulation, and I'll probably touch on this a couple more times, that corporate governance in charities tends to be rather more formal, even in quite modestly sized charities, and it tends to have rather more in the way of checks and balances than you typically tend to see in a commercial organisation. Let me have a look at the different types of charitable organisation. I mean, this for me is part of the fascination of dealing with the sector, is just the ecology of the different types of vehicle that can be used to run charities. So the ones you're most likely to come across are going to be companies limited by guarantee. You will also have charitable incorporated organisations which have taken off quite considerably in recent years. One of my personal favourites is the Registered Society, which you may know as an Industrial and Provident Society. They've been through a change of name. And there are all sorts of other types of corporations. Some friendly societies are bodies corporate, and you can have charitable corporations that have been set up by royal charter or private act of parliament, or which might just be corporations because they are. You also get unincorporated charities as well, charitable trusts, foundations and associations, and there are different issues associated with dealing with those, of course. And just by way of comparison, you also have a diverse ecology across the rest of the third sector as well. And I've added to the list there companies limited by shares, which cannot be charitable organisations, and community interest companies, which also cannot be charitable organisations. And we've got credit unions and trade unions as well. Trade unions are interesting because they are most definitely mutual organisations, and they are not corporations, yet in so many ways they act very much as if they were bodies corporate, but technically they are not. And something else that is very common in the sector is composite organisations. So I have quite frequently seen quite complex, it's not quite right to call them group structures because they don't have that parent subsidiary relationship. It tends to be more complicated than that. So you might find a close association with common trustees operating a charitable company limited by guarantee, which might have one or more trading subsidiaries, which will be companies limited by shares, and which might operate alongside a registered society, a BenCom society that's doing some non-charitable but not-for-profit activities beside it all. And you might actually then find that there are some charitable trusts tucked away within the organisation as well, where it has perhaps absorbed other charities in the past. So you can find that it's actually quite a complicated structure, and the normal family tree isn't quite adequate to show the relationship between them. You will know that it's a charity that you're dealing with because the trustees will tell you. Just as an aside here, in a charitable company, the directors are called trustees, and they will normally have a non-executive role because that is required for corporate governance purposes, and the executive of the company will be the next tier of management down. So they will be doing the jobs that you would expect a director to do in a a senior in a commercial organisation, but they won't actually be directors. They will be the senior management, and the directors are likely to be non-executive. But anyway, the trustees, they will tell you it's a charity, and their accountant will confirm that to you, and you will almost certainly check with the Charity Commission just to make sure. Most charities are registered with the Charity Commission, but some are not because they may be exempt or exempted. I won't talk about that right now because that'll go off in a bit of a side direction. But most that are not registered are registered with another regulator. So a university, for example, has its own regulator. Housing associations have their own regulators, and those are not registered with the Charity Commission as charities. Let me move on now to look at what you will find inside a charity in terms of its assets and the restrictions that there may be on using them. So I'm going to start with an unincorporated charity. Not quite sure why, because that's just making it a bit more complicated. But you will have the charity itself as an unincorporated charity does not exist as an entity in the same way that the partnership doesn't exist as an entity. It is just the sum of its people and its assets if it's an unincorporated charity. So outside the charity, you will typically have the founder and donors and funders who will be making money available to the charity. That money will come into the charity through the control of the trustees and the officers. In an unincorporated charity, legal title to the assets will be vested in the trustees. They will be the registered owners of the land. The bank account will be under their control as the signatories. But they won't have beneficial ownership of the assets. They're not their assets. They belong to the charity. And what that actually means is that they are regarded as being held on trust for the beneficiaries of the charity. Now, this isn't as direct as the sort of trust you'll get in the bankruptcy, where the family home is held on trust for husband and wife, because in that situation, you can calculate the share, the exact percentage that the joint owners have in the equity. The beneficiaries of a charity do not directly have a share in the equity. The equity is there to benefit them, to benefit the charitable purpose, but they don't as individuals have a direct say in it. The important thing for you as, let's say, liquidator of a charity is that beneficially you can't regard the assets of the charity as being available to you as liquidator necessarily, and you can't necessarily regard those assets as being available to pay the creditors. What you've actually got is personal liability. And again, we're talking about an unincorporated charity here. You've got personal liability of the trustees or the officers or both to pay the creditors of the charity. And the trustees themselves will have an indemnity from the funds of the charity. So they will have the right to use the funds under their control in the charity to pay the creditors, to pay the liabilities, but only within the scope of the indemnity that they have got. And that's the same for an incorporated charity in much the same way. There, of course, the charitable corporation does have legal personality, so it is responsible for paying the debts to the creditors, but it holds its assets on charitable trusts, which means that it can only dip into those assets to pay the liabilities to the extent to which it has an indemnity that is wide enough to allow it to do so. And in this diagram here, you'll see the directors are outside the charitable corporation. They are regarded as the trustees of the charity. They don't have personal liability. They direct the corporation, they are its agents, but they should not normally be personally responsible for the debts, because they are contracting merely as agent for the charitable corporation, and the charitable corporation is the contracting party. Now, when it comes to categorising funds, there are many different categories. I hope I've got all of them here, but probably somebody will tell me that I've missed out something that's important. What charities like is unrestricted use funds, because the clue is in the name there. They have got a very, very broad indemnity there. As long as they're using those funds within the charitable purpose, they are available to pay the running costs, which means the creditors of the charity. Moving down the scale, you have restricted use funds, which will be for a particular purpose within the scope of the charity. So restricted use funds might possibly fund one employee of the charity, but perhaps not the payroll as a whole. So restricted use funds may be available to pay some of the creditors, but possibly not all of the creditors. Then you have land and buildings where there are legal restrictions on being able to sell or mortgage them. You have expendable endowment, which can be used to some extent to pay the bills of the charity. Permanent endowment, which is very difficult to tap into, and then you sometimes find that there are funds that are actually held on another charitable trust. So like a Russian dole, you can find a charity within a charity, and I'll say a bit more about that in the context of cathedrals in a few minutes. So when you look at the assets that the charity has got, you have to remember that you have to look at those in terms of funds and different categories of funds, and not just as assets. Just as in the same way as if you were administrator of a law firm, you wouldn't be able to use the client account balance to pay the administration expenses or to pay a dividend to creditors generally. As in the same way with a charity, funds are often limited in terms of what you can use them for. And essentially, it will all depend upon the indemnity that you have got for a particular fund to be used for a particular purpose. And that indemnity is either a 1 or a 0. You've either got it or you haven't got it to pay a particular class of liabilities. Okay, I'll move on now to look at cathedrals, because that is in the title of the talk, so I probably ought to say a bit about it. This is really partly light entertainment and partly also because cathedrals do offer some quite interesting insights into how charities work. There is a new cathedrals measure, which is it's like the Companies Act for cathedrals. It sets out constitutionally how they work, and there's going to be a tweaking to their constitution so that when the cathedrals measure, the new cathedrals measure takes effect, the cathedral will have a single body corporate, which will be made up from the members of the chapter of the cathedral. Now, probably the constitution of each cathedral will be completely unique, because cathedrals have been around for hundreds of years, and each one will have developed with its own history and its own constitution, its own way of doing things. But the chapter, this body corporate within the cathedral, which legally is the cathedral, the chapter will be a registered charity. It'll be registered with the Charity Commission, and it will almost certainly contain restricted use funds. I say here it will probably contain endowment funds. I'm not so sure about that, because the general rule is that a charitable company cannot own endowment funds. Cathedrals may be different, because the body corporate that is the cathedral is not a Companies Act company. I'm not quite sure what it is exactly. It is a cathedral body corporate. Anyway, the cathedral building itself will be in a protective charitable trust. So this is one of these Russian doll situations. So as well as the chapter, there is also going to be a separate charitable trust, which will be controlled by the chapter. They will be effectively the trustee of that charitable trust. But the property in that protective charitable trust will not be available to pay the liabilities of the chapter. And if the chapter should collapse, should be dissolved, then that charitable trust will survive and will be transferred to a charity that will supervise it. So essentially, this ring fences the cathedral building itself and the land it stands on and other important treasures that that particular cathedral owns. I can imagine that, for example, in the case of Salisbury Cathedral, that will probably include the Magna Carta that they have in the chapter house there. And those are assets that you will simply not be able to touch if you were to be the liquidator of a cathedral. Now, something else that we don't yet know that will follow the new cathedral measure is whether it will be possible to use a CVA as a restructuring tool for a cathedral. In 2004, Bradford Cathedral went through a successful CVA, but the law has changed since then, and it's now pretty clear that cathedrals cannot use CVAs. And this is quite typical of some of the types of organization that you might find in the charitable sector, that although you might be dealing with a body corporate, it may not have the full range of Insolvency Act procedures available to it. That's not unusual at all. Now, the proposal on which the new cathedrals measure is based is that cathedrals should be able to use CVAs to restructure. I can't actually see how that works in the cathedrals measure, so whether that's going to be amended before it gets royal assent, I don't know, or how they're going to be dealing with it. Maybe there'll be some secondary legislation, I just don't know. But the intention is that cathedrals should be able to restructure through a CVA, but the law doesn't allow them to do so, and at present I don't see how the law will allow them to do so. So let's move on from the specific point of cathedrals to finish off by looking at some of the typical issues that you're likely to find in insolvencies in the charitable sector. The first thing is, as always, the people. And you will be reminded very early on in dealing with the charity that this is an organisation that's driven by values and not for value. And a lot of the discussions will be concerns about how they promote the objectives of the charity if the charity has to cease trading, and what continuity they can offer for whatever projects they're involved in, whatever people they're helping at that time. The second thing that's going to be hugely important is personal liability, and perhaps to a lesser extent, personal reputation for the trustees of the organisation. And I've found that I've sometimes been the independent advisor to the trustees of the charity. This has very often been a major issue, and although it's not really an issue, because if it's an incorporated charity, then the liabilities stick with the incorporated charity. But nevertheless, it is a real worry for the people concerned, and you can expect to spend a little bit more time offering reassurance on this than perhaps you would for a commercial company. The organisation itself will throw up some issues. I've already mentioned that charitable corporate governance tends to have more checks and balances. A very practical effect of this is that you will need at least one extra meeting before you get anywhere with this, because you will have a meeting at which you will have to explain how it all works and what your recommendations are. The trustees will go away and they will think about it, and then they won't come back with a decision. They'll come back with a request for another meeting at which you will have to cover the same ground again. And this is partly due to the natural caution that is imposed by the checks and balances of the charitable corporate governance. And it's also a result of them wanting to make sure that they properly understand who makes the decisions to wind up the charity. And particularly if you're talking about a company limited by guarantee, which is probably the most common sort of vehicle you will encounter. Company limited by guarantee has members, and the members have, under companies law, they have a supervisory role, a supervisory function over the trustees, but that's something that is of very little significance or relevance in corporate governance, because the trustees are likely themselves to have that role of strategic non-executive control over the executive. So the existence of the members is something that is often something they've not had to be particularly concerned about beforehand, and so that can be one area of confusion as well. Second point about the organisation is you shouldn't assume that the full range of insolvency procedures are going to be available. They very often are not. If it's a company limited by guarantee, you should be okay, but if it's something other than a company limited by guarantee, you're probably going to want to check quite early on what your options actually are. And there's often an indirect answer to that question, so it may be possible to convert the organisation from one sort of entity into a different one, to convert it into something like a company limited by guarantee, so that you can then take advantage of the range of insolvency procedures. And the final point here is the assets themselves, and you shouldn't assume that you can realise the assets to pay the expenses of an administration or liquidation, or to pay the creditors. You're going to have to do a little bit of due diligence into the types of funds that the charity has got and the restrictions on those funds, to find out what is actually going to be available. There's one other topical issue that I'm just going to mention, which is that on Friday, I got sight of a press release from the Charity Commission. I'll just see if I can put that up on screen with you. Here we go. Just saying that the Charity Commission has appointed an interim manager to the Kingdom Church GB in South London. So that's an example of just one of the things that can go wrong for a charity. In this particular case, the Charity Commission were originally concerned last summer that this particular organisation was selling COVID cures that didn't seem to have much scientific basis behind them. And having investigated that, I think they've now got concern about what might have happened to some of the assets in the charity. Let me just go back to the slides now, and I think we're now able to we've now covered the points that we wanted to cover. So this is now the opportunity to ask questions. So if you've got any questions, please do ask them now. If you want to drop me an email afterwards, please do so. And I hope to see some of you at the Neil Taylor Insolvency Conference at the end of this month. And I hope to see some of you as well at the next coffee break briefing in April, which is going to be on the theme of the new regulations dealing with pre-pack administrations. So thank you very much, and I'll stay here for a moment or two longer if you've got any questions. We've got a question from Nathan Bickley-May. Excellent question. If we have a solvent liquidation of a charity so that there is a surplus after creditors have been paid, what do you do with that surplus? And Nathan has actually answered the question himself by saying, do you pass it to another charitable organization with similar objectives? And yes, that's exactly what you do. Yes, the surplus is held on the charitable trust, so it has to be paid in accordance with the charitable trust. The easiest way of doing that is to find another charity with compatible objectives. You can pass the money to them without breaching obligations as charitable trustees. If you can't find another charity with similar objectives, then the trick is to change the objectives of the charity that you have got, so that you're then able to find another charity with similar objectives. But yes, thank you, Nathan. That's an excellent question. Right, with no more questions then, I will say thank you all very much. Bye, and see you again, if not before. Thank you and goodbye.